chose to file a Section 16 order, Section 16 application.
They participated which proceeding?
Before the arbitrator.
Right.
They filed their pleadings. They appeared. It went on for about 6 months. They appeared before the tribunal. They filed their Section 16 application, in which they raised the plea that they should never have been impleaded, and the tribunal doesn't have to.
Prior thereto, in what proceedings did they participate before the trial?
My lord, because notice was issued, I filed my claim where I had made them a party.
Right.
Which is what, in the impugned order, the learned judge takes note of the fact that I had made the procedure followed was a little different, because my lord, I am the counterclaimant. I'm the counterclaimant, but initially what I filed my counterclaim as a separate claim before the tribunal and made them a party to my counterclaim,
right.
Which at that point was termed as a claim.
Yes.
So the arbitrator solicitor issued notice to them. They appeared before the arbitrator, and then they filed their Section 16 application, raising an objection to their impleadment. But they did appear before the arbitrator, and they participated in those proceedings. They did not challenge the initial order whereby notice was issued to them by the tribunal. And they chose to file a Section 16 application, against which no challenge would lie. In fact, we had raised the issue of maintainability at the outset before the High Court.
Yes. The arbitrator passed a speaking order on why you were impleaded?
My lord, some order was passed without my presence. That is on, my lord's 23rd of May 2024. 2023, my lord. Which is also impugned in the Section 37. If your lordships have my prayer at 100. That is impugned, my lord. Then I filed a Section 16 saying that please don't implead me, number 1. And number 2, my lord, that your lordship, that the tribunal has no jurisdiction. So 2 orders were impugned in 37, my lord. And the first order.
So we look at the matter on merits, whether there was a ground on the basis of the group of companies doctrine for impleading them. Let's see at the end of it if you are correct and you satisfy the court that look, ultimately they were.
And discovery principles are not applicable.
Then we can affirm the order. But just give us a short note, both of you. We can keep it maybe after, we keep it next Friday or when?
Whenever it lodges.
You can give us a short note of 2 pages each on what basis.
I had handed over my note, my lord, which is
yes.
It's filed also, my lord. If the lordships have that note itself, it's in the office report. It's just a 3-pager.
Alright, we look at it.
Yeah.
You also give us a short note, then we will have some idea on what basis you are seeking to implead them.
And my learned friend, my lords, as far as Section 11 order is concerned, may not be right. She has not seen the additional documents. We have placed the entire order, my lord.
Really?
Yes, my lord. And that order itself says, my lord,
yes,
that
when senior counsel states that the appellants have filed in note challenging the impleadment of the appellants as parties to the arbitral proceedings, even though they are not parties to the arbitration agreement. Stop. The response, the call that counsel appearing on behalf of the respondents states that likewise the respondent will also file a short.
I'm only on behalf of respondent number 1. The remaining respondents are actually their group companies.
All right. We have issued notice.
yes.
You can serve your group company.
Yes.
You're not really aggrieved with them.
Right.
States that you would file a short note of submissions on its 3 pages by the next day. This one, we'll keep it next Friday. We'll look at both your. Let's see. Yeah. We will keep it after 2 weeks.
No difficulty. Because I am praying for a stay. Because kindly see the impugned order. As far as the way me, yes, but he's proceeding ahead.
That's our difficulty. May the order gets passed where they're impleaded, they come to court in January.
Adjourn it to a date beyond the next 2 weeks. That's all.
Yes.
My lords, in any case, we've only been directed to file our affidavits of evidence. Nothing.
My lord,
no.
kindly see the peculiar nature of the direction the impugned.
respondent to my counterclaim. But because of the impugned order, now the two cases have merged. So they are simpliciter respondents, and so am I a respondent.
The respondent evidence
First, the claimant is their group company. They have to lead evidence
The
first.
original claimant will lead evidence first.
Clause.
After which the burden will come on you because you are already in a counterclaim, you have a claim.
just have a look at page 73, my lord.
We'll look at it.
Yes.
Obliged, ma'am.
Lord, we'll request the arbitrator, my lord, to defer.
My lords, let only at least the affidavits be filed.
We will deliver an award in the next few days. The original claimant will file his affidavit, etc.
Yes, we also still have to file our affidavits.
They have to file their claim affidavit, yes.
But direction is also to me to file my
We
affidavit.
are keeping it after 2 weeks.
Very well.
Obliged.
Please, Your Lordship. Your Lordships had granted me time to seek instructions by when the rules will be ready regarding implementation. Your Lordship, 4 to 6 weeks. Work is already happening on it. Within 4 to 6 weeks, my statement may be recorded. We'll have the rules ready.
That would not be, the time schedule which they have essentially prepared, that would essentially exclude me
This
from the
exam, not Your Lordship, but then for the next one, because it has to be as per the rules, there is actually an AIBE committee headed by honorable judges and academicians and all of that.
My lord, if I may, please consider my contentions here. My lord, as regards my eligibility, that stands crystallized by virtue of a constitutional bench decision of this court. What this court did was, as regards all other niceties.
They are framing the rules now.
No, my lord, but I would be losing 1 year, and all similarly positioned persons, I would not be in a position to write this exam. That is what she is claiming.
When is the exam?
First, we are collating that frame rules. Now, that will take 4 to 6 weeks. That is the minimum time. Anything.
We'll say 4 weeks, so that we'll keep it on the 19th. Tell us on the 19th.
Please, Your
Apply with the constitution because body for it.
Not-
This is all is specifically observed that those who are that students who have cleared the exams to be eligible to pursue the final semester of the final year exam should be allowed to take the AIB.
Now I have cleared my final exams also.
They have cleared the final exam as well.
Yes, sir.
Your
But I will not be.
Lordship, that was not, we are implementing it. There's no denying that we are implementing it, but
The learned counsel appearing on behalf of the Bar Council of India states that that BCI is in the process of framing rules governing the conduct of the
AIBE exam, Your
All
Lordship,
India Bar examination.
pertaining to the
How many petitioners?
My lord, 9.
The 9 petitioners, you said all of them have cleared the final year?
Exam.
they have not cleared the final year yet. I'm sorry, no, Your Lordship.
My lord,
Their result is awaited, if I am correctly understanding.
my lord, it is already declared. It is already declared.
Your final year result is also declared?
Declared. No, I will not. My lord, we all hail from different
All right. All the petitioners are stated to have cleared the examination, the LLB examination, the final year LLB examination. Stop. So, nothing further.
No, my lord.
Your Lordship.
I will not be in a position basically, and I will not be in a position to get my certificate, consequently get enrolled.
But you have cleared the exam. You will have a provisional mark sheet.
Yes, my lord, which I will not get it anytime soon. It might take its own time. My lord, the practical difficulty.
Provisional mark sheet you should get.
My lord, in order to write the AIQ examination, I should be enrolled in a bar council, state bar council. Devoid of it, I will not be allowed to.
This shall be permitted to register for the AIBE, for which the last date of registration is
That is what I
25 October 2020. We are passing an interim order in your favor. You will be registered.
May I submit,
My lord, there are large number of.
Your Lordship,
Please
that's,
take it representatively.
that's
My lord, this is-
actually, that's actually,
my lord, there are large number of students who hail from traditional universities, the state universities and central universities, where the results are not declared. Every year the results get delayed. Even in the last year, the results got delayed. One of the high courts pulled them up and said, please consider it within a period of 2 weeks. That was not done so. We have lost one academic year as regards large number of people. Well, why do we have to lose 1 year? They they have a fiduciary responsibility towards us also.
Your Lordship, if I may
The above direction,
Whatever.
shall be followed by the Bar Council of India in all other similar cases, bearing in mind the
Your
judgment of the
Lordship,
Constitution Bench, the
may I-
Bar Council of India versus Boni Foy Law College, 2023, 7 SCC 756.
Your Lordship, may I submit?
How can you say that we will not follow a CB judgment?
We will follow it, no difficulty. Your Lordship, last time also I had read para 55. Your Lordship said left it to us, but we are not saying we are implementing rules. Your Lordship said earlier indicated that Your Lordship will list it after 4 weeks. Your Lordship have it after 4 weeks. The rules will be in place and we will make the arrangements.
But let
This
this
order
law
you got-
appear for the IIB. Why should they lose a year?
Yes.
Then
It will affect somebody's right to enter judicial service, so on and so forth, you know.
Then Your Lordships are directed similarly placed. Your Lordship, that will create Your
You
Lordship.
should have done it. Justice Paul's judgment is 2023.
Please, Your
You take your sweet time, then we have to protect other students.
Then Your Lordship, may I just submit, because last time Your Lordships had indicated that just the timeline for the rules may be submitted and I've got those instructions.
For this exam, you why 6 weeks to take 12 weeks. But this time don't prevent students who are in the who have qualified for the final semester from appearing for the exam.
Your Lordship, for that we will have to amend the notification and we will have to place it.
It's an order of the Supreme Court.
Will Your Lordship have it on Monday? Just on Monday. I'm not asking for anything else. Because Your Lordship, I had only sought. There are many other things which will have to be put in place.
The relevant part of Boni Foy is para 55, right?
55.
45,
Where
46,
Your
47,
Lordship-
Give us 1 second. Just
page
give us.
37, madam. Page 37. Paragraph 45 to 48.
The Bar Council of India versus Boni Foy Law College, 2023, 7 SCC 756, the Constitution Bench had observed thus. Para 46, 47 and 48 copy that.
Your Lordship, also 55, I had indicated last time, where Your Lordships have said that these are the suggestions which the learned amicus has given and left it to us to implement it. Because Your Lordships at that time also realized.
You have a copy of the judgment?
Your Lordship, it's fine. Page number 39, Your Lordship, of the paper book. Page 39 of the paper book is para 55.
1 second.
My lord, paragraph 45, it says, however, in view of large ramification, we do consider appropriate to delve into some of the aspects. Though not all the aspects which may get involved in the All India Bar examination, essentially in view of submissions of the learned amicus.
Judgment?
Your Lordship's PDF page should be page 50, Your Lordship. PDF page 50. That should bring Your Lordship to para 55. May I read that, Your Lordship?
Or reading it special for my eyesight focusing on the judgment.
Oh, sorry. Your Lordship, it's PDF page 50.
Yes, just read it out now.
Please, Your Lordship. While all the above suggestions the learned amicus had given, including this suggestion, and then Your Lordship said, while we agree in principle with the suggestions of the learned amicus curiae, these should receive the attention of Bar Council of India urgently in the process of steps taken by the Bar Council of India in view of this judgment. At that time also Your Lordship contemplated that we'll frame rules. I agree that Your Lordship, we have not framed rules till date, but I'm saying in 4 weeks, Your Lordship may have it after 4 weeks. Because at that time also, let me complete now. Your Lordships contemplated that it is and left it to us. Because Your Lordship, it cannot be done like this, that we will have to frame rules, otherwise it will be mayhem, especially in a notification which has already been issued. How will we verify whether all of them have cleared their exam or not? We will have to check with the universities. There'll have to be some mechanism in place, Your Lordships. Considering that Your Lordships had left it to us. Have it after 4 weeks, we'll have
I take the Lordship to page
Lordships may put some
37.
directions.
This was precisely considered. Page 37, paragraph 45. What this court did,
45. Just
Yes,
read it.
but from the middle,
Just read the whole paragraph I say.
Yes, my lord, the effect of the
read the whole paragraph.
the
effect of the view expressed by us would be that it has to be left to the Bar Council as to at what stage the All India Bar Examination has to be held, pre or post. There are consequences, especially in respect of intercom period, which would arise in holding the AIB in either scenario, and it is not for this court to delve into them, but it will be appropriate to leave it to the Bar Council of India to look into the niceties of both the situations. However, in view of larger ramifications, we do consider it to appropriate delve into some, though not all of the aspects which may have been involved in the AIB, especially in view of some suggestions made by the amicus curiae. We may take note of the fact that AIBE is scheduled to be held twice a year. It is necessary that this schedule should be strictly followed, as otherwise the students with law degrees would be left idling their time. One of the questions which arose whether only on passing the examination from the law university or obtaining such a degree should the person be eligible to take the AIBE. In India, various recognized institutions providing law degrees often declare results at different times. The concern is that a person on account of non-declaration of a result may lose out on the opportunity to appear in the All India Bar Examination, leading to a fairly long hiatus period of time without having an opportunity to work in the board proceedings. We are inclined to accept the suggestion of the learned amicus curiae that students who have cleared all the examination to be eligible to pursue the final semester of the final year of the course on production of the proof of the same could be allowed to take the AIB. The result of the All India Bar Examination would be subject to the person passing all the components required under the course of study of the university/college. This would be subject to All India Bar Examination result being valid for a specified period of time. My lord, as regards this particular proposition itself, this court held that we accept the suggestion of the learned amicus curiae. My lord, even in the last academic year, a large number of students who are enrolled, who studied from state universities and central universities, who are strapped of resources, whose results got delayed, they were not able to undertake the AIB examination. The same thing is happening this year. My lord, policy paralysis on the part of the respondent cannot be the basis to scuttle my Article 19 right.
Your Lordship, it's not policy paralysis. Your Lordship had left.
Was this judgment delivered?
This judgment was delivered
May.
on 5th. I'll just give the date.
This was delivered on the 10th of February 23.
Yes, ma'am.
Is
What is Bar Council of India doing?
Your Lordship will frame the rules. The only attempt was that in the Gaurav Bansal matter, Your Lordships have given directions.
The constitution bench of this court delivered judgment in Bar Council of India versus Bonnie Foy Law College, 2023, 7 SCC 756, on 10th February 2023. Good stop. On the aspect of holding the All India Bar Examination, the observations of this court, or the observations of the Constitution bench, are contained in paragraphs 45 to 47, paragraph 45 to 48 of the opinion of Justice Sanjay Krishnan Paul, which
लाइव कर रहा हूँ, रुको.
below. Just copy down at page 48. Full stop. In paragraph 55, the Constitution bench, while agreeing in principle with the suggestions of the amicus curiae, observed that the suggestions should receive the attention of the Bar Council of India urgently in the process of steps taken to implement the judgment. Full stop. So the judgment was delivered on 10th February 2023. It appears that rules have not yet been framed by the Bar Council. Stop. In fact, Learned Counsel appearing on behalf of the Bar Council of India had sought an adjournment before this court to enable her to take instructions on the time frame within which the rules would be framed. Stop. This court is now apprised of the fact that rules are likely to be framed within a period of 4 to 6 weeks. The urgency of the situation arises because the last date for the registration for the AIBE is 25 October 2024, while the AIBE 2024 is scheduled to take place on 24th November 2024. Full stop. Bearing in mind the above time frame, it would be manifestly unjust if a large number of students who have otherwise qualified in terms of the prescription or in terms of the suggestions which were made by this court in the above judgment are deprived of the opportunity of appearing for the bar AIBE 2024. Full stop. We therefore direct that for the ensuing examination, the bar council shall permit students who have cleared all examinations to be eligible to pursue the final semester of the final year course of law. The Bar Council of India to permit to allow registration of all students who fall within the ambit of paragraph 48 of the judgment of Bonifoy Law College as reproduced earlier. Full stop. We have passed this direction, conscious as the court is of the fact that absent such a direction, students who are appearing, students who have appeared who are appearing for the final semester from several universities, including state universities, have no control over the date of the holding of the final examination or the declaration of the result. Such students not be left in the lurch by postponing the date of enrollment. Stop. The above directions shall operate as directions in rem, the Bar Council of India, to govern the ensuing examination which is to take place on 24 November 2020.
Your Lordship may not dispose of the matter then, because we would like to place the rules before Your Lordship. Your Lordship's issue notice, because notice is not yet issued.
Why? We'll conclude it now.
Your Lordship may issue notice. We will bring the rules to Your Lordships then, because then I'll have to also...
Already pass an interim order.
Interim order. And then...
So long as these bills can appear.
Please, Your Lordship. Please, Your Lordship.
Copy to NMC Council, Your Lordships. We've served it even to Mr. Sharma, Gaurav Sharma, Your Lordships. This is regarding the PG Neet exam.
Yes, Mr. Sharma, are you appearing for?
I appear for NBE, National Board of Examination. We conduct the examination.
You have conducted the PG examination.
Please.
Now, they are seeking here the question papers, answer keys, answer sheets, raw and pre-normalization marks.
Other is with regard to the normalization. 3 days before the exam, they bring in this as a knee-jerk reaction, Your Lordships. Also, Your Lordships, as far as the rules are concerned, there are no rules, there's no clarity.
You want your response sheets.
Your Lordships, only two things, and more than that...
What do you confine your prayers to?
Yes, Your Lordships. There are 3 things I want to confine my prayers to. First, Your Lordships, is as far as the statutory provisions are concerned, they suffer from the vice of overbreadth, Your Lordships. There is no regulation. They have a rule-making, a regulation-making power, but they haven't made any regulations with regard to how the exams will be conducted. Everything works on an information bulletin which is put online, which can be changed at their whims and fancies. And in this case, Your Lordships, 3 days before the exam, they changed the entire basis of the exam. They split it up into 2 sessions. That is not as a part of their normal, as their information bulletin. There is normalization. There is a distinction between 2 groups. One group has suffered, one group has not suffered. So there has to be some standardized above, so that
the reply will issue notice.
Very good. Please, Your Lordship,
will you file a reply in 2 weeks?
Please.
Because it's some urgency.
may I pray for 1 week, because the counseling is going to happen and all our selections.
Because a similar petition, because here, because the additional issue that they have raised is regarding the normalization.
Ayush Patel, right? It was the National Board of Examination.
No, because
Your Lordship,
Kanya.
pending the
Kenya versus MD,
Anyway, you file a return here.
that is coming on 18.
Same issue raised there.
Because some of the issues raised here.
Which bench is that before?
Because
My learned friend gives me the details, I can look into that.
we don't know where it
Anyway, we'll do this. We'll issue notice and ask them to file a return in 2 weeks.
Right. We will file.
And it's coming before we get clarity. That bench, tag this with that.
Please.
May I request your lordships to give them only a week's time because counseling.
Yeah, the reason why we already file a reply in a week because counseling is to start.
Yes.
They are saying that look, you have not given regulations, so everything goes by the brochure. And 3 days before the entire pattern of the exam is clear. How can you do all this?
Because
Same with the license.
we haven't done anything new, unusual or unique.
Oh, it's obviously very unusual.
Followed prelims.
6 days before the examination.
It's contrary to the previous information.
You'll have a meltdown. I mean, if you are.
Because I will explain in my affidavit. Because after what happened in
File your affidavit in a week, come back next Friday.
We are appearing in the similar matter, my lords, Ayush Patel.
Milos Union should be here because we only conduct the
This Tanvi, who is that bench? Which is that bench which is taking up Ayush Patel? Is it before our bench?
Yes, yes.
When is that coming up?
Because there is no next date. The periods are
This
coming.
Ayush Patel with this matter. This Ayush Patel with this matter. Particular matter.
because I am told Ayush Patel is disposed of.
No, that's not disposed. There's similar written Ayush Patel was disposed of.
There are two matters by the same name and
I think it is dismissed as instructual.
That's right.
yes.
So we'll just list this matter next Friday.
The office report.
But Milos Union
Another
should
Ayush Patel.
because counselling is conducted by Union. And Milos, so therefore they said
India is the party.
against
These
you.
proceedings.
No, your lordships, we have not, but we'll implead them. There's no
But
difficulty.
They are a
Plus,
party.
Ayush Patel is pending.
Milos, they're already a party. Union are already a party.
Issue notice.
Notice has, I'm
nobody
sorry,
is there.
notice has.
Yes, we actually noticed to the union.
Great.
Because Ayush Patel is pending.
It is pending, right?
Yes, yes.
So, एक बार check करो, वो dispose of the new one. So then you can.
The
tag
writ is pending.
Your lordships, the 17th, I
एक बार check करो order क्या है, last order.
Yes.
All right.
grateful.
Please do my notes. Well, it's a very large issue of repercussion arises. In Malans, any state, and Telangana is picked out. Just see, Malans, how serious this is. Telangana, whom I appear, has a domicile requirement that for taking the Neet exam, apart from the general seats, everybody must be for local people resident there plus 9, 10, 11 there. 4 judgments of your lordships directly in my favor, including a constitution bench.
From the 85% state court. And followed in Assam.
As well as in judgment after judgment have upheld my requirement is 9th, 10th, 11th in Telangana.